Testimony, there may be questions.
I hope I'm unmuted. Am I unmuted?
We can hear you.
Okay. Thank you, Chair Klayman. For the record, I'm Mark Regan, the Legal Director for the Disability Law Center of Alaska. And as you were saying, it's correct. We were plaintiffs in a lawsuit against the Department of Health and Social Services about the way the system worked for taking people in for involuntary evaluation and then maybe for involuntary treatment. And the system had broken down and people were being stacked up in jails and in hospital emergency rooms, which led to the lawsuit. What has happened since is we settled the lawsuit, and we settled the lawsuit on the basis of state encouragement of something called Crisis Now. And Crisis Now is a worthy idea. It's the idea that when you're having a crisis, there are different ways that the system can help you. Listening to what you have to say, bringing you to very short-term places to recover from your episode of mental illness, having you in short-term facilities like the crisis residential centers under House Bill 172, or perhaps giving you 30 days or more of mental health treatment at a place like API. And the Crisis Now system would make it easier for people to receive short-term treatment that could stabilize them and get them back out into the world, hopefully with links to outpatient mental health treatment. And it's because House Bill 172 has improved through the committee substitute that you're now considering, would help people get treatment in the short term that would stabilize them, that we're here to support the bill. The committee substitute makes two basic improvements on the prior versions of the bill. One improvement is that whenever you're taken into custody on an involuntary basis, the new version provides for an ex parte order to be obtained from a judge or magistrate that would appoint a lawyer for you. One problem that developed last year as the committee was considering the bill was that there was some doubt that in every situation a lawyer would be appointed for you, and the committee substitute fixes that problem. In every situation, a lawyer is appointed for you. The other improvement in the bill is that it makes it clear that if the system is going to hold you anywhere for longer than 3 days, you get a hearing. You get the attorney appointed for you at the outset, and you and the attorney get to participate in the hearing. And only if the judge approves would you be held for an additional few days at a crisis residential center. Only if the judge approves would you be committed to a place like API for 30 days of treatment. And that wasn't clear from earlier versions of the bill, and this is an improvement. No matter what happens, you get your 72-hour hearing and can go forward with it. Those are the things that are the focus of my testimony today, that there have been improvements in the bill, and with the improvements, we are pleased to endorse it.
Thank you very much. Is there anyone that has questions for Mr. Regan? Representative Eastman has a question. Go ahead.
Thank you. And through the chair, just for the benefit of the committee, could you update us on what the resolution or status of that lawsuit is?
Through the chair to Representative Eastman, we settled the lawsuit in 2020. That is the legislative session before this one. One of the components of the settlement was everybody was agreed that Crisis Now was a good idea. And one of the things we agreed on in the settlement is that the state would introduce legislation to implement Crisis Now further than had been done already. And that's what we agreed on. That's what the state has done. The impetus for Crisis Now really comes from the Mental Health Trust. But a good idea has lots of people who would like to agree to it. And Health and Social Services has agreed to the general idea. We at Disability Law Center, who had the lawsuit, have agreed to the general idea. And our settlement actually calls for further progress on Crisis Now.
Thank you.
Any other questions from members of the committee for Mr. Regan? I don't hear and seeing. I would note there should be, you all should have received it electronically. There was a letter that he sent on behalf of Disability Law Center that should be now as part of the record on the bill that's in the files and should be in your notebooks. Thank you very much, Mr. Regan. And I would note that Representative Vance joined us about 5 minutes ago, and that Representative Kirka has joined via teleconference as well. Yeah, Representative Kirka. And we're going to go, we now have other folks on Teams or on the phone that can provide further testimony. I'll note who is available. Steve Williams is here is on Teams from the Alaska Mental Health Trust. Steve Bookman, the Assistant Attorney General with the Department of Law. Jennifer Moreau-Johnson, Division of Behavioral Health, Department of Health and Social Services. Heather Carpenter is online. And then Nancy Mead, the General Counsel for the Court System, is here in the room with us. So if there are particular questions that you have about the legislation, particular issues we may have touched on last time, now is the time, and we can figure out who might be best to answer those questions. Representative Eastman, you look like you have questions, and your hand is up.
Thank you.
We're using our usual 1 minute time limit.
I'm curious. Now we've got various deadlines that we're talking about. Most prominently, the 72-hour deadline. What happens when weather is a factor, particularly in remote communities? Is that an exception to the 72 hours, or if you're not able to get to a treatment facility or whatnot, is that a factor that we should be considering?
I think that's probably a question either for Ms. Carpenter or Mr. Bookman.
Through the chair, Mr. Chairman, if I could answer that. My name is Stephen Bookman. I'm an Assistant Attorney General with the Department of Law.
Please.
Yes, through the chair, Representative, the idea is that the 72 hours begins upon when you get to the center, either if you go to a crisis stabilization center before you go to a crisis residential center, or if you go to the crisis residential center immediately. But the 72 hours would start upon getting to the facility. However, you would have a lawyer, as Mr. Regan noted, and if there was some sort of problem, the lawyer would be able to bring that up with the court before you arrived.
Follow-up?
Representative Eastman.
All right, so I suppose if there were to be weather delays, then that 72 hours could be somewhat longer than 72 hours. Am I correct in that?
That's my understanding. Mr. Bookman, is that your understanding as well, that if there are weather delays or problems, may not be a weather delay, just may not be able to get an airplane in time, would those circumstances delay the start of the 72 hours?
Through the chair, yes, the idea is that the 72 hours is sort of the clinical time for observation. But from the patient's perspective, the respondent's perspective, yes, it could be longer than 72 hours.
Thank you.
Other questions from members of the committee? I'll bring back a topic that we had some discussions about on Friday. Could you all give a little bit more of an update about guardians and how the bill changes the current status quo with regard to notification of guardians? Like, where are we today, and where will it look like if this bill becomes law? Ms. Bergman, you're on the screen. You may or may not be the right person to answer that question.
Through the chair, this is Stephen Bookman. I guess let me take a first crack at that. Right now, there's a statute that talks about how notice shall be given to guardians. And in my experience with civil commitment hearings at API, there is certainly API tries to call a guardian when they know there's a guardian. They don't know that in all cases. If they've met somebody before, they may well know that. Often those people have public guardians. It can be difficult to connect to the guardian just because the public guardians are very busy. And sometimes I try to call the guardian if I think that I might call the guardian as a witness. Sometimes the public defender will call the guardian. But it is a process that's not particularly formalized. I think API always asks about it and tries to contact the guardian, but there's less in statute about that. The bill provides that when someone is at a crisis residential center, right, and the court sets the hearing, the court will notify the guardian of the time and the place of the hearing. We expect that would improve the quality of notification because the court should have the best sort of database about who is a guardian for who. Maybe there's a private guardian, a relative or something. It could be that a ward/patient identifies a guardian. Maybe they've got the wrong guardian, or maybe they do have a guardian, but the patient isn't really in a place to answer that question. And so we think it will improve the general notification of guardians, if that, maybe that's a start at answering the question.
Ms. Carpenter, anything you want to add? I do note that we received, I think since the last hearing on this bill, the court system provided an updated fiscal note, and Ms. Mead is here, and she can provide some information on the court's fiscal note. Before we hear from Ms. Mead, Ms. Carpenter, did you want to add anything about notification to guardians and how it contrasts with the current status?
Sure, Chairman Clayman. Stephen Bookman did provide the general overview of how it currently exists, but just in plain terms, right now, there is no actual requirement in statute to notify the guardian. So this formalizes that process, sets it across the board so guardians are notified, whether it's a public guardian like the Office of Public Advocacy or a private guardian. If you're going to get in terms of how that will actually be carried out, that I would give to Nancy Mead with the court system, but it should make this the same across the board for everybody. So we do think that, and the respondent proved that communication.
Okay. Ms. Mead, can you come and tell us a little bit about the court system's fiscal note and how the court system will manage it? And I think if you could also provide information about, for guardians, whether is it all public guardians, is it private? Not all of one or the other, but what's the current makeup of guardians from the court's perspective between public and private guardians?
Thank you, Mr. Chairman. My name is Nancy Mead, General Counsel for the Alaska Court System. To answer your second question first, we did do some research into the court view database to try to determine how many guardians are public, that is provided by the Office of Public Advocacy, versus private, who are typically family members or something else. The results were actually a little bit surprising and showed that the majority are non-OPA guardians, that is private persons appointed as guardians to care for an incapacitated or an individual who needs some sort of protection. I will add that I'm not as confident in this data pull as I am in most of the court system's data that we provide. This is not something that we track in in an easily pullable way. Our data folks did a sort of workaround to try to get to this answer. I'm not positive of the results, and because, as I say, it's not something that we track. But I will say that it's probably true, generally, that there are a good number of private individuals appointed as guardians, maybe more than people previously thought. So with that, I'll talk a little bit about my fiscal note. As the prior testifiers represented, there is not currently a duty, at least on the court system, a statutory requirement to notify guardians when when somebody comes in for an involuntary mental commitment or any other type of mental or commitment proceeding. This bill adds 2 times now that the court will be responsible for notifying guardians. The first is on page 6, line 3. That is when an individual, a respondent, is admitted to a crisis residential center, and the court sets a time for that 72-hour hearing. And the second would change the existing practice for involuntary mental commitments, page 9, line 28, and that would add the requirement for the court system to notify that guardian. It is also the case that the court does have the information that probably the other entities involved in this do not have. That is, the person has access to court view, and these cases being confidential are not readily accessible by others who have some access to court view. So these are confidential. Our fiscal note includes 2 Range 12 clerks who will actually be responsible for handling this increased notification requirement. The reason that we can't absorb this work in our existing probate office is, first of all, that probate office is extremely busy already. But the main issue is most of the mental commitment cases happen to be filed with the court after hours. I don't know why that is, but we would expect that many, if not most, of these crisis interventions and hearings will be handled by a magistrate judge who sits in Anchorage after hours 24/7 to handle emergency proceedings such as this. So since they are after hours, we don't have a probate staff available to do the notifications that this would call for until the next day. And so to implement it appropriately, the way I believe the committee intends, that is to have the guardian know right away when their next hearing is or what is happening with their protected person, we would need somebody to do that work in the middle of the night or on the Saturday night or whatever. So that's why we have 2 clerks who could do the follow-up and implementation of this as the statute would require.
Questions from Ms. Mead? All right, hearing and seeing none. Thank you very much. I think the only other question that I had become aware of was a couple of folks, kind of unrelated, had asked whether the Crisis Now structure will be accessible to minors, to children, and whether this is a resource that would be available for children in crisis or whether this is only available for adults. And Ms. Carpenter, can you provide some response to that question?
Absolutely, Chair Klayman. For the record, again, this is Heather Carpenter with DHSS. The crisis stabilization process would absolutely be available to minors, just like the current statutes address both minors and adults. I will note we already have providers who are standing up these services and performing them right now for minors under our 1115 behavioral health waiver. And we anticipate, just like we have now, we will have some of those providers, if this bill were to pass, to say that they would like to perform these services in an involuntary commitment setting as well. And then we, again, would assume some providers would not. Just like the current process, if a minor does have commitment proceedings started against them, the parent or guardian has to be notified, and they have, rights that follow the minor through that system, and a parent can currently sign in a youth to treatment centers now. So high level answer is yes, youth will absolutely be able to access this system.
All right.
Can you hear me? This is Rep. Snyder.
Yeah, Rep. Snyder, go ahead. Representative Eastman is in the queue too, but you haven't asked any questions, so you can get the first run at that. Rep. Snyder.
Thank you. Related to this question of notification, I want to make sure I understand correctly. So with minors, I would imagine an attempt would be made to reach their guardian even before the responsibility would turn to the court for notification for a hearing. Is that correct? Like reach out to guardians would happen almost immediately. Is that typical practice, or am I not understanding correctly?
Through the chair, Rep. Snyder, I believe the answer is yes. I will let Mr. Bookman add some legal information. I will note that guardian ad litems are also appointed in these cases, and that when an attorney is appointed, both the youth and the parents each get an attorney appointed in those instances where they need one. But on the legal question of how they're notified, I'm going to punt that to Mr. Bookman.
For the record, this is Stephen Bookman with the Department of Law, and through the chair, we have existing law that talks about how a minor can give consent for medical services if the guardian of the minor cannot be contacted. And so, to my mind, the only way you would know that the guardian cannot be contacted is if you try to contact the guardian. And I believe that shows a duty to try to contact the guardian. We also have notification provision, as Ms. Carpenter noted, and also as a practical matter, we would expect that parents and guardians will be the ones bringing minors to these facilities in the first place.
Thank you. Follow-up, if I may?
Rep. Snyder.
Thank you. Okay, thank you. That was my understanding. Thank you for confirming. And then, so extending that to the issue of adults who may have guardians, I guess I want to understand current practice. I understand what this bill will do with respect to notification once there's going to be a hearing. But how common is it, if at all, are attempts made to contact anyone, a relation or who may be responsible for an adult brought to a center? Is that not really a thing? I understand there's probably no way to know. I just didn't know if there are folks that you see on, on a more frequent basis that you know and are familiar. I'm just trying to understand how often a guardian or an adult actually is contacted earlier on in the process, if at all.
Through the chair, this is Stephen Bookman. With regard to the practice at API, if they know that somebody has a guardian, they will, social work will always try to call the guardian. And there are a number of people who sort of come back to API, and so they do try to do that. In terms of legal statutory thing, it is, I don't want to get too wonky here, but, one statute refers to under 725 that, the guardian shall be notified of the respondent's rights, but then under 715, there's no mention of notifying the guardian. Instead, just talks about notifying the respondent and the respondent's attorney. And so the new bill is intended to address that, as Ms. Mead stated. So certainly people try to contact the guardian because if nothing else, API, wants to sort of know more about what's been going on with the patient. But it can be, I don't want to say hit or miss, but it is not guaranteed that they will be able to reach the guardian.
Understood. Thank you for that.
Representative Eastman.
Thank you, through the chair. Just to back up a little bit, I'm just curious, how do we envision that this process will be initiated? So we're going to end up with someone, being potentially taken to one of these facilities. How do we anticipate, or what's the intention as far as that process? Where does it start?
So just for clarity, so we can know do you mean how does the process go, that somebody gets brought to a crisis center, Or how does the legal process start once they're at the crisis center and they're saying they don't want to stay there, so they become an involuntary commitment? 'Cause
Yeah,
they're
the
kind of-
former, where someone's first being contacted by someone and then they end up in the process.
I'll actually leave that open, whether that's a Carpenter question or a Bookman question or a Steve Williams question about how does somebody, even before there's a application for legal proceedings, how does somebody end up at a crisis center? That may be more a Steve Williams question than a Heather Carpenter question. Steve, you want to take a shot at that?
Sure. Good afternoon, Steve Williams, CEO for the Alaska Mental Health Trust, and Heather can chime in if there's any details that I miss. But the intention here, through the chair to Representative Eastman, the intention here is that we're transforming the current system. And in doing that, there are various components of the envisioned system that we're in the process of developing and implementing. The first is a crisis call center. So a person could call a crisis call center and may have the crisis actually resolved on the phone without having any other intervention. And the respondent, the clinicians on the other end of the line, a clinician or a peer, would be taking the information from the individual, trying to assess the situation, de-escalate it, maybe referring them to other resources that are available to them in the community. If that doesn't work and a community has what we call a mobile crisis team, a team that's made up of a clinician and a peer, someone with lived experience and in recovery, the call center could dispatch that mobile crisis team to the individual in the community where they're at to meet with the person or persons, address the issue, assess the situation for safety, address their concerns, and hopefully resolve it right then and there. We have these teams currently operating in Fairbanks and Anchorage. And then if for some reason this gets to the bill, if some reason the situation is so acute that it can't be resolved then someone gets transported to an available treatment center in a community. In this case, in Anchorage and in Fairbanks in the Mat-Su Valley, we're trying to stand up the 23-hour, 59-minute crisis stabilization center. So someone could be taken there. If the situation can't be resolved in that particular time period, they can be referred up to a longer stay, up to 7 days, at a crisis residential center. One of the things that I would like to point out about the process, and that's important about this bill, is not every community is going to have the assets or the ability to stand up all the components that I just described, but especially in places with like rural Alaska. But rural Alaska might be able to stand up a crisis residential center near the regional hospital. So there are pieces of the model and components of this bill that allow for the implementation of the pieces statewide.
Follow up?
Representative Eastman.
Thank you, through the chair. Now, the process you just laid out was, someone calling up the call center, and that would trigger, some other activities. What about if it's not the person having the crisis that's making the call or somehow referring, making authorities aware of a situation? How does it work in that kind of situation, where it's not self-initiated by the person experiencing the crisis?
Through the chair, Representative Eastman, I don't have experience working in dispatch where normal emergencies, when someone hits the 911, how that situation is, kind of assessed, and then the appropriate response is deployed. But I would imagine that in this situation that I just described, again, you would have trained professionals who would be receiving the call and then working through their protocols to assess what the best response is.
Follow up?
Representative Eastman.
Thank you, and through the chair, I'm curious. So, if that is that 911 dispatch, and you have a peace officer that's making contact with someone, is that one of the ways that someone could get referred into this process?
Through the chair, Representative Eastman, yes, we're not removing law enforcement or other EMS first responders out of the ability to respond to a situation and then maybe transport someone. What we're really trying to do is avoid that to the extent that we can, because we know that their primary responsibilities are in response to public safety or medical emergencies in the community, and they may not be the best equipped with mental health training and otherwise to be responding to the situation. I would also just add that just the mere presence of someone in a uniform or flashing lights can escalate the situation unintentionally.
Follow up.
Representative Eastman.
Thank you. Recognizing that in a lot of communities that may be the only person that can get dispatched, at least for some period of time, I'm just wondering if it's coming in from that law enforcement peace officer referral, how long until someone that's a clinician would be actually potentially making their own professional recommendation on what should happen with that person in that crisis? And is that, potentially 72 hours later, or what kind of timeline are we talking with before someone would either be able to, leave the process because it's not something they've voluntarily initiated, or they've reached that clinician who's making a more professional medical type of assessment?
So just to get a little more clarity on the question, I think you're asking actually two different questions. One is a person say a police officer brings a person to a crisis stabilization center or a crisis residential center. I think there's the first question about how soon will they see a medical professional of some type. And then there's a second question which you're asking, which is when you will actually have a diagnosis of some kind. And I think, as you can appreciate, that diagnosis might not happen in 15 minutes or a shorter period of time, but actually seeing a medical professional happens much sooner. I think Mr. Williams can address both of those, but it's like when you go to the emergency room, you see the nurse that does the triage. You're seeing a medical professional. You may not get diagnosed by the physician for some time, but they see a medical professional fairly quickly. I think Mr. Williams can address that.
Yeah, I'm not really asking so much about the medical diagnosis. I'm asking for that determination on whether or not the person can leave and go on their own recognizance, or whether they should be held for some period of time.
Mr. Williams, if you're the best
Sure.
person, if that may be, you can start.
Through the chair, maybe I can start, and then maybe either Heather or Stephen can add in the details. Through the chair, Representative Eastman. So when a person is brought to either the Crisis Stabilization Center or a Crisis Residential Center, they are to receive an examination within 3 hours. And I think that's part of what's outlined in the language of the CS. Certainly that's something that we want. We want people, as soon as they're dropped off, to be taken in by medical and mental health professionals to be able to assess the situation for the individual's safety, and then best how to resolve their crisis so that in the shortest amount of time possible. And then maybe Stephen or Heather, do you want to answer the second part of that question?
This is Heather Carpenter. So Heather Carpenter, DHSS, and through the chair, Rep. Eastman. It's a great question, and I'm not going to insert our judgment for professional clinical judgment. It's going to depend on each individual patient that enters, currently what I referred to last week, a DET, or a Designated Evaluation and Treatment Center, or these new crisis stabilization centers or crisis residential centers. Per the law, if they are held involuntarily, and per the CS, that's where that 72-hour clock starts. The clinician will start examining them and their team as soon as the individual enters the facility. We talked to a couple of clinicians over the interim, and I think, some referred to having a good baseline understanding at 48 hours, but it's going to depend on the, acute crisis that the individual may be facing. If they need to prescribe a period of crisis medications to, calm the patient down and to get them stabilized or not. So it's definitely something that we could bring in, or you could ask a psychiatrist or, somebody who would have a very particular professional judgment. But we're leaving that to the professionals to determine on a case-by-case basis about how long. And I will note that at any time, per the statute and per the CS, if a person no longer meets commitment criteria, they cannot be held any longer.
And follow-up?
Representative Eastman.
And so who all is empowered to make that determination that someone no longer meets detention criteria?
Through the chair, Representative Eastman, I believe that would be the mental health professional as defined in 473915, as well as the professional person in charge, also defined in that same part of statute.
And follow-up?
Representative Eastman.
So to try and flesh out how this is going to work in sort of real life, so if you have a member of law enforcement who, their assessment is this person needs to go to a crisis residential center or a DET, but there's a period of time, weather delays, plane delays, what happened, and they're not able to make it there. Once the law enforcement officer has initiated that process, are they empowered to turn it off? If, I don't know, maybe they've been waiting a week for weather and it's not clearing, and can they then, in their own professional judgment as a non-clinician, say that this patient is no longer in need of crisis residential center visit?
Through the chair, Representative Eastman, I want to share one piece of information, then I'll let Stephen Bookman share about the specific legal piece. However, per our settlement with the Disability Law Center, one thing we were required to put in place was a reassessment or a reevaluation situation if, like a situation you're saying, that DHSS is unable to provide secure transportation to API or another DET. After 48 hours, it is on the department to set up a reevaluation with a mental health professional in order to ensure that a respondent is not sitting in a rural hub or held in a community jail, just floundering without seeing if they still meet criteria. And that was actually a particular requirement that Judge Morse ruled we had to set up a process in order to do this.
And follow-up?
That's fine. I would just note what Ms. Carpenter described is not part of House Bill 172.
Understood.
All right. Representative Eastman.
Thank you, through the chair. And so that assessment after 48 hours, again, we're talking about someone who's not able to physically get to one of those mental health professionals. Is that something that would take place over the phone or over a Zoom meeting, or how would that work, just so we can understand?
Through the chair, Representative Eastman, I think we're doing those via telehealth methods. Our contractor who we have so far signed up, I know, is True North. I mean, I could follow up to find out exactly the methods. They've had to do a few of those, but I imagine it could be a combination of telephonic as well as a telehealth.
Thank you. I have another question, but I'd like to give an opportunity for others to ask first.
Anyone else on the committee have questions for any of the folks here with us today? Representative Vance.
Thank you, Mr.
And I would also note that Deputy Commissioner Al Wall is also on the teleconference. He may also offer thoughts on response to question. Representative Vance.
Thank you, Mr. Chair. I think this question is for Mr. Williams. What is the percentage of those calls that are received that are self-reporting? Because from my understanding, is that we're trying to avoid the involvement of law enforcement if necessary, and utilize the mobile crisis team to respond to hopefully not escalate a situation. So what's the percentage of those self-reporting and taking advantage of the crisis call center versus what we've been doing in the past with law enforcement being called to a scene?
Through the chair, Representative Vance, I don't know that I have that specific information to provide you today. What I can tell you is what we know from other communities that have implemented the model is that, you know, when someone calls, or the person in crisis, or a loved one calls for a person in crisis, in Maricopa County of 100 calls, you know, 90 of those calls get resolved on the phone. And then the remaining 10, a mobile dispatch or a mobile crisis team gets dispatched to address the situation in the community. They resolve 7 of the 10 responses, and then the final 3 individuals either end up at a crisis stabilization center, or in some cases a crisis residential center, the longer term 5 to 7 days of treatment.
And just for the record, Maricopa County is Phoenix, Arizona. Any follow-up,
Thank you,
Representative
Mr.
Vance?
Chair.
I think that helps kind of understand a little bit of my questions here, but I do have a question on the bill where it has page 11, where it has definitions and about the health officer, because we're expanding authority to not just include police officers, you know, law enforcement, but we're including health officers to have this capacity now. What is the scope of their authority? And I don't know who this question should go to for the legal.
We'll probably start with Stephen Bookman. He's the lawyer here with us.
Yes, again, Stephen Bookman through the chair. Representative, the current definition of peace officer actually includes things like a public health nurse, which you might not think of as a health officer or as a peace officer. And so what the bill does is it creates it uses an existing definition of peace officer, which is more what we would traditionally think of as an actual peace officer, and then takes the definitions that maybe don't quite match and calls them health officer, and includes, like a paramedic or a firefighter, because those are the people who are probably going to meet people in mental health crisis. And then as to this bill, a peace officer or a health officer are the ones who are authorized to sort of start the involuntary hold process to bring them to a crisis center.
Follow-up?
Representative Vance.
So what kind of training is the public going to have as an assurance that these health officers have the full capacity to be able to make these decisions?
Through the chair, Representative Vance, I would say that most of the current statute doesn't change anything. Most of the bill doesn't change anything. It's the same kind of people: a public health nurse, a local health officer. It does add a paramedic or a firefighter. Those people will have specialized training, and they'll be a licensed nurse, or the training that you would usually get as a paramedic. And what they have is the authority at that point to take you to the crisis center. After you arrive at the crisis center, you must then, as was said before, be seen by a mental health professional, which is a currently defined term, including a physician, a clinical psychologist, a advanced practice nurse, or a registered nurse with a master's degree in psychiatric nursing, a licensed clinical social worker. And those are the people who see you after you arrive at the center and begin the process of evaluating whether you actually need to stay there, or whether you should, simply go about your business.
Okay, thank you.
All right, Representative Eastman.
Thank you.
Actually, just a second. Representative Kirka, Representative Snyder, any other questions? Representative Eastman, I think, has another line of questions. I want to give you all a chance to jump in if you're interested. And Representative Drummond, too. I know you're with us.
Yes, Mr. Chairman, actually, this is Representative Kirk. I do have question here.
Please proceed.
And I apologize for not being there in person. I'm looking through the work draft or the CS. I could not get the CS until just a few minutes ago remotely here. And I'm kind of wondering, where is the criteria in the bill? And I apologize if this was covered earlier. For what we would determine, what are the criteria for determining somebody can be held against their will, I guess, is the question. What kind of behavior patterns or what kind of explicit detailed behavior or criteria that we would use to justify, I guess, holding someone against their will?
And I think that's a Stephen Bookman question because I don't think, well, yeah, go ahead and answer that question, Mr. Bookman.
Yes, thank you. Through the chair, Representative, what we would be looking at is whether there's probable cause to believe that somebody is likely to cause harm or is gravely disabled. That is the current, we would be using the same definitions that we use today. It's just that we would be applying them in sort of this other, well, it's the same definitions we use today. Likely to cause harm, meaning somebody who is likely to hurt themselves, likely to hurt others, or has a plan to hurt others, and then gravely disabled being something along the lines of, you're going to end up hurting yourself, not because you intend to, but because you just sort of can't take care of your basic needs, whether that's the idea that maybe you're going to freeze to death, because it's winter, or maybe because you just aren't going to eat because that's not something you can really figure out. So it's using the existing definitions.
Very good. And then where is that fault, Mr. Chairman?
Follow up, Representative Kirka.
Thank you, Mr. Chairman. Through the chair, where is that in statute? And I apologize if it's right in front of me in the bill. I just need to write it down here.
Sure. Representative Kirka, through the chair, the current definitions are located in 47.30.915. Likely to cause harm is number 12, and gravely disabled is number 9.
Follow up, Representative Kirka.
Thank you, Mr. Chairman. Yes. And then who would be in a position to make a judgment on this criteria? Could it be somebody just calling in and reporting a neighbor, or somebody you see in the street? Would it have to be whoever's the first responder, if you will, showing up on the scene? Who would make that, I guess, that judgment about somebody needing to be taken to a crisis center?
Through the chair, Representative Kirka, if we're talking about somebody being taken to the crisis center, that would be a peace officer or a health officer in the bill. If we're talking about somebody remaining at the crisis center when they get there, that would be a mental health professional. Again, a defined term that's defined under current law, which could be a licensed clinical social worker, a professional counselor, a psychiatrist, an advanced nurse practitioner, someone with a degree of professional licensing.
And then a quick follow-up, Mr. Chairman.
Representative Kirka.
Thank you, Mr. Chairman. Through the chair. And then once somebody's taken to a crisis center, is it the same criteria for taking them as for the mental health professional deciding that they should stay there?
Yes, through the chair, Representative Kirka, yes. I would add that, yes, in terms of substantive criteria, yes. To the extent that someone, a mental health professional, wants to say that somebody should be held at the crisis residential center, they also have to petition the court that they reasonably believe that the problem will resolve during the shorter stay at the crisis residential center. Well, it may be that somebody comes into the crisis residential center or crisis stabilization center, and it becomes, apparent very quickly that what they need is 30 days of hospitalization. And if that's true, we would expect the medical professionals to sort of go to that step and not have somebody be at a crisis residential center when it's clear that what they need is, perhaps 30 days of hospitalization. But yes, it's the same criteria all along. Once you no longer meet the criteria, as Ms. Carpenter said, you should no longer be held.
And just note, Representative Kirk, in connection with one of the earlier queries, some of the material that we've distributed, there's a 3-page handout from the Department of Health and Human Services and the Mental Health Trust that's titled at the top, Definitions for Alaska Involuntary Commitment Statutes, House Bill 172, and it's got a number of definitions that come right out of statute, and that should be in the materials that have been provided earlier. Did you have any further follow-up, Representative Kirka?
No, that's fine. Thank you.
Thank you very much. And Representative Snyder, I'll give you a chance if you have questions because I can't see you. I'm just making sure you don't get lost in the shuffle.
Thank you, Mr. Chairman. I'm good. Thank you.
Representative Vance, did you have any question? I think I saw your hand up, but maybe I was mistaken.
Yes, thank you. I do have one clarifying question. Probable cause was mentioned, and I was just wondering, are the people who are in this process, because there's a legal proceeding that could take place, are they required to provide proof of probable cause of bringing that person into the residential crisis center or any of the centers?
I'll let I think Mr. Bookman is the best person to answer probable cause questions.
Yes, through the chair, Representative, what we would say is that there's supposed to be an application to the court for an involuntary hold, and in that application, there will be an explanation of what's going on that the mental health professional believes there is probable cause. There'll have to be a description of the respondent's behavior. We imagine it, from current practice, what I've seen when these things are granted for detention at a hospital, generally what professionals do is they describe how a person is communicating, whether they're logical or not, their physical condition, if they appear to be not taking care of their own physical needs for hygiene or wound care or what have you, and how they are acting, whether they are, catatonic, or whether they are sort of unable to stop moving or something like that. But it would be in that application that would be the description.
Follow-up?
Representative Vance.
Thank you for that. Just for clarification, so it would be the medical professional that's doing that. Are the people who are the health officer or, someone on that first level of bringing someone or anyone in the mobile crisis team, are they required to have proof that they've brought them all that way before they have contact with a medical professional who's going to be making the assessment? Do they have to have proof of why they were detained? I think detained might be a strong word, but do they have to give a reasoning legally as proof of why they thought it was necessary to bring them to the health professional?
Through the chair, Representative, what we're trying to do is we're making a process similar to the current process. Right now, a police officer or a physician can do an emergency hold on somebody, and that emergency hold for 24 hours is something that is not judicially reviewed. We trust these professionals to make those judgments. In terms of, whether there's, and we expect that would continue. If a police officer brought somebody to a crisis stabilization center, we would continue to assume that would be appropriate. To the extent that a mobile crisis team would be doing that sort of thing, they would have to keep records due to their Medicaid certification, and CMS and other regulatory bodies would be reviewing that. There would not be a judicial review of that in real time, however.
And just so, I think this may provide some clarity. I mean, today there's times when police officers fill in an ex parte application for a 72-hour hold because they think somebody needs to go, say, in Anchorage to the Alaska Psychiatric Institute. So police officers are trained and fill out those forms and describe the conduct and present that to a judge, and the judge agrees, then the person is held. So that can be done today for a 30-day commitment, start a 30-day commitment process by either a physician or another mental health officer under the bill, as well as a police officer, before they ever get to the center. I mean, that can happen today, and that would still happen under the bill.
Well, under the bill, we're expanding some of that authority with health officers. And I'm just trying to understand, a person's legal rights in this process. If we're going to expand authority to other individuals, I'm just wanting to make sure I fully understand, like, the process as we walk it out and who gets to make what decision, and that the individual rights are protected in that, where there's that proper balance. So
Mr.
thank
Brookman,
you for that clarification.
Yeah. Mr. Brookman, I think you probably can provide more details than I can. I just thought it's important to know that today people are applying for and getting ex parte orders for people that haven't actually been in custody or been involuntarily held. Or that's I guess that's really the beginning of the involuntary hold, is the police officer says, you're a danger to yourself or others, and I'm taking you into protective custody, effectively.
Yes. Through the chair, Representative, the health officer definition is not so much an expansion so much as a splitting of the current definition, right? Because the current definition includes peace officers, traditional law enforcement, and also currently a municipal or local health officer, a public health nurse. We shifted that language into the new definition of health officer, but substantively, those are the same people. The people we've added to health officer are trained, licensed people, paramedic or firefighter. And so those people will be, I think, the appropriate sort of people to do that hold. So it's not an expansion of the definition as we see it so much as of a clarifying of it. We realized that we needed to add, paramedics or firefighters to make this work, particularly in Anchorage, because it's the fire department that would be doing the mobile crisis team. And, it just made sense to, instead of trying to create a definition of peace officer that somehow includes firefighter, to sort that out to having peace officer mean the common sense term of peace officer, and creating a definition of health officer with people who have specialized health training who deal with mentally ill.
Thank you.
I think Representative Eastman, everyone else had a shot, so you're back in the queue.
Great, thank
You
you.
were never out of the queue, but I just figured we should give everybody a chance.
Yeah, very good. I think there's a lot of questions here that are great questions. So my question through the chair is, and to be very clear, so when you've got this EMT or this paramedic or this firefighter or this police officer that's made an initial assessment that this person is likely to cause harm to himself or others, or gravely disabled, or whatever the trigger was to get them into this process, before they reach the point of handing them off to that licensed professional in mental health and whatnot, did they have the discretion to stop that process at any time, or are they required at that point, once they've called the center saying we're going to bring someone in, are they required to complete that process and hand that person over?
Sure. I think it may be me trying taking a crack at that question. Through the chair, Representative, we're not trying to limit the discretion of law enforcement. There may be times when a law enforcement officer, encounters somebody and thinks, this person needs to go to jail, this person needs to go to an emergency room, this person needs to go to a mental health crisis center. And so we are trying to expand their options. If they are, driving with the person to a location and they think they understand now what's going on with the guy, and actually maybe they could just drive the guy back to his apartment, they would retain the discretion to do that. Whether or not they would, I don't know. I mean, I would defer to, police standards in that.
And follow up?
I'll Representative Eastman, I'll give an example that we've had some of these discussions. A person with a known history of psychiatric illness, adult, that lives with their mother, and for whatever reason, this person became convinced that mom took a plane and has gone to Mexico for 2 weeks, and so the person is just in crisis because mom left for 2 weeks. In fact, mom went to the store. But the person's in crisis because they think mom's on the plane to Mexico, and the police officer comes and thinks, well, I don't really know this person, but I'll take this person to the crisis center. The person's been to the crisis center before, and if they got to the crisis center, they'd say, you're looking for mom. They'd know how to call mom. They'd call mom. Crisis would be averted. They'd get, mom would come pick them up. Well, in that same scenario, the police officer, might be driving and say, yeah, I've seen this person before, and they might call the crisis center and say, oh, do you remember so-and-so? Do you have the number for mom? Because he thinks she's in Mexico, and the police officer calls mom and gets mom on the cell phone, and she says, oh, yeah, I'm just at the grocery store. I'll be back in 30 minutes. You want to just meet me back at the house? I'm sure once I'm at the house, he'll be just fine. And the police officer, instead of going to the crisis center, then drives back to the house and waits with the person until mom arrives from the store. I mean, that's a scenario that isn't real. I don't think that's, at least when we've talked about it in different discussions, this is not something that, these are real things that really happen. People think that somebody went to Mexico when in fact they went to the store, and the crisis goes away pretty quickly. Mm-hmm. And that's an example of tremendous discretion, but that's just a little more clarity on your query. But please proceed with
Very
your
good,
next
thank
question.
you. And so I'm wanting to know now, obviously, the peace officer and maybe some of these others can initiate an arrest in some of these situations, but we're giving them an opportunity not to arrest the person, to instead, send them to a DET or whatnot. Now, is it the intent that the police officer be able to, communicate to the patient, I could arrest you, but if you voluntarily go this process, then I don't have to. Is that anticipated? Is that intended?
I know, Steve Williams, you had your hand up for something earlier. Do you want to take a first shot at this, and then others can add in? My committee aide pointed out that your hand was up on the screen, and I didn't see it. So
That's okay. Through the chair, I'll take a crack at this, and then I did have a follow-up comment, if that's okay, on the previous question.
Please.
Representative Eastman, I don't know what the dialogue would be on the street between a law enforcement officer and someone in a behavioral health crisis. But we do know that law enforcement has the first crack at discretion at determining the situation, the risk to the public, the risk to the individual, whether an alleged crime has or hasn't been committed. And what we're really trying to do here is set up a system where first responders, including law enforcement, can take a look at the situation and realize that there's another option where someone in a behavioral health crisis whose underlying issues really are instability and access to care, to be able to take them to, hand them over to the professionals who've been trained to deal with medical and mental health crises, and then be able to turn around and get back out onto the street for traditional law enforcement EMT type responses.
And was that the additional information you wanted to provide in the earlier question?
Mr. Chair, no, the additional information I wanted to provide on the previous question was you gave the example, and I thought your example was well put. There is a lot of current coordination that happens between law enforcement, first responders, to the extent that they can access mental health professionals in the moment, to try and figure out what the best way is to respond to, Steve's crisis at home. That's really not the role of law enforcement or other EMT or other first responders. We don't want them to play the quote-unquote social worker. They're doing that because they want to make sure the individual in crisis, they can help facilitate access to care in the community. The current system we're trying to stand up here and what we've been talking about today allows them to know they can take someone to a place in the community in a crisis, hand them off, and be able to trust that those professionals are going to they're going to manage the crisis, and then they're going to negotiate and navigate and refer the person to the appropriate services in the community. So again, first responders and law enforcement are going back to doing their traditional roles and responsibilities that we often think of when we think about firefighters, EMTs, and police.
Thank you. Follow?
Representative Eastman.
Thank you, and through the chair. Now, I want to assume, of course, that what we hope that no one abuses, this process in any way. But I want to ask, what safeguards do we have either in statute or in the bill to prevent abuse of the process at that, initial stage where, obviously you can't just arrest someone for no reason. You have to have reasons. But if you don't, even if you don't have reasons, you could threaten that, hey, I might do something to you, like arrest you, if you don't voluntarily go along with this process, going to a crisis residential center. I could see someone abusing that process and coercing someone against their will to voluntarily enter the process. What safeguards do we have in place to keep that sort of thing from happening?
Sounds like a Stephen Bookman question.
Actually, Mr. Chairman, this is Heather Carpenter. I'll take first crack, and then
Okay.
I'll let Mr. Bookman, do cleanup. So, again, Heather Carpenter, DHSS. So there's a number of safeguards, including patient rights, and there's a whole, litany of rights that patients have when they are involuntarily committed, including right to counsel, right. I can, list some others, and I'll have Stephen Bookman give the exact reference. Additionally, the Centers for Medicare and Medicaid Services have oversight, to current hospitals that have these facilities. And, we have our licensing and review folks who go in and make sure that, people are following treatment planning, they're following, all of those grievance procedures. Additionally, each individual facility, we imagine, will have a grievance procedure. So if a patient, doesn't feel like something is going right, they can start that grievance process, against the individual provider. There is also the ombudsman. So if an individual feels like they were treated wrongly by the state through this process, especially at API, they can go to the ombudsman. If an individual feels like a police officer handled the situation wrong, we have the Police Standards Council. So I will stop there and see if Mr. Bookman has more to expand.
Through the chair, Representative, I think Ms. Carpenter gave a good explanation of it. I think in my experience reviewing the files of people who come through API, I think people are not inclined to invoke involuntary processes if they can think of a way to not do it. Steve Williams may be able to speak with this, but I think everybody in the field believes that it's always better to get buy-in from the patient if you can get it. That leads to better outcomes, fewer interactions with mobile crisis teams or the police, and a better long-term outcome for the person. I mean, we're expecting that the police officers and other law enforcement, that they'll know their communities, and they'll want, John Jones or whoever it is to just be doing his own thing so that they can focus on sort of their traditional, crime investigation, crime prevention, arrest sorts of powers. But I would echo what Ms. Carpenter said.
Okay.
Hello?
Representative Eastman.
Thank you. And, I agree. Certainly we have safeguards for someone who's been arrested. And we have safeguards for someone who's the subject of an involuntary commitment. But, it seems to me through this bill we're paving the way and essentially encouraging people to follow a third process. They're not going to be arrested. And they're not going to be involuntarily committed. They're basically, in lieu of being arrested, they're going to voluntarily commit to participating to some degree in this process. And I just want to make sure, do we have any safeguards for this third process so that people aren't, being coerced into starting this process when they really shouldn't be?
Through the chair, Representative Eastman, I want to take a step back because, we don't see this as a different process. This currently already exists when somebody is facing a psychiatric crisis, has not committed a crime, so it's very different than the criminal statutes. When we're looking at a civil involuntary commitment, it is because they meet that definition of gravely disabled and those other concerns. So currently, this process already exists. This is statute that has existed on the books for, say, 40 years. But individuals, because we don't have these lower level, less acute facilities, they are sitting in an emergency room, or in the instances like Mr. Regan shared earlier, when API had a much lower census, we were having to hold people in a protective custody at a community jail in Anchorage, which is what nobody wants to do. So individuals currently are sitting in an emergency room, without any actual care. It's just an observation. We're not able to give them that emergency psychiatric care while they're sitting in an emergency room until we get them into the Alaska Psychiatric Institute or one of our DETs, which currently the only 3 in the state are Fairbanks Memorial Hospital with 20 beds, Matsu Regional Medical Center with 16 beds, or Bartlett Regional Hospital with 12 beds. So this process is the same as it exists now, except for it is less restrictive and more appropriate levels of care. So instead of a police officer having to take somebody to an emergency room, they're able to take them to a facility that can start that treatment right away.
The only thing I would just add to what Ms. Carpenter noted is that the stay at a crisis residential can be voluntary, but it can also be by court order and by authority of law. So it isn't a situation where if you're not in a a DET facility that you would have to be voluntarily in a crisis residential. This specifically allows for court processes to hold somebody in crisis residential for a shorter time than 30 days. Did you have a follow-up, Representative Eastman?
Yes, follow-up, and I know the department may not think of this as a new or different process, but I'm looking at the broadening, if you will, of the definition of peace officer, and obviously we're dealing with firefighters and EMTs and paramedics and so forth. And just, if someone can tell me, maybe there isn't an answer, but are there any safeguards to prevent the kind of abuse that we were just talking about? And if they're not in this bill, then maybe we need to look elsewhere in another bill.
Through the chair, Representative Eastman, the items I alluded to before would still exist. So those patient rights, the different avenues that people have, as well as I would add that any of the providers like an EMT, a firefighter, there's professional licensing that are over those. So in addition to the other places I referenced, you can always go if somebody mishandles a situation that is not overseen by the department, such as the professional judgment of a peace officer or a firefighter, an EMT, you can go to the board that licensed those as well.
Thank you. Follow-up.
Actually, before we follow, I would note that on that topic, I think the essential protection is the hearings. That you have one could say, well, everybody goes down to the courthouse with an ex parte application to hold somebody for 72 hours. And the judges don't read them, they just rubber stamp them and let them hold them. But actually, that's your first protection. First protection is that they won't get an ex parte application granted because the judge says, no, this isn't the evidence I need to hold somebody, I'm not going to hold the person. And then the second fundamental protection is where at the 72-hour hearing, they'll now have an attorney that's appointed, and they'll have a judge, and it'll be a contested hearing. And if they don't think they should be held, the attorney's going to advocate for them not to be held. So your two most fundamental protections are the review by the Judicial Department.
Thank you.
But Representative Eastman, you'd have a follow-up, and then after you finish that, Representative Drummond wants in the queue. She's been quiet all day, and then Representative Vance.
I'm noticing, and it hasn't come out yet, so I just want to make clear my understanding is correct. So I see that we're adding VPSOs to this definition of peace officer here now, in addition to some of the other entities that are part of this process. I'm looking at the statute, someone who poses a substantial risk of bodily harm to themselves or others. What protections do we have in place to keep someone from, coming to the conclusion, maybe an EMT, for example, I happen to be one, coming to the conclusion that, this person I'm talking with, they just, told me that they don't have a vaccination. I think that they're a potential, risk of harm to themselves or others. What safeguards do we have to make sure that doesn't happen?
Representative Eastman, through the chair, I know in the instance of VPSOs, they also have oversight of the folks that, license them, for lack of a better, option. So I think that would be the best oversight. Additionally, the department, again, I'm going to reference the settlement we had with the Disability Law Center. We have provisions in that settlement that we need to provide training and offer training to our police officer friends to just share about, how to kind of recognize somebody in a mental health crisis, when it might be appropriate or not. To what to do when somebody's in a crisis. I will also reference that, a couple years ago, there was a great bill that had, for folks with disabilities, where they could get a designation on their license, if they experience an invisible disability that might look like somebody's in crisis or experiencing something that isn't, that, that's a voluntary recognition, so they could provide that to the police officer, because if somebody is stopped, they may, that may raise some panic. So I think there are some other options that exist for individuals in these situations. But again, it is on the department, again, to offer some training, because we certainly don't want the police officer to misrecognize a situation where somebody meets the criteria per the statute and they need, medical assistance, versus they may just be eccentric and doing their own thing. Individuals are able to do that. So I'll stop there.
I'm going to let Representative Drummond have a chance. She hasn't had a question all day, and I'll let her have a chance at a question or whatever, any follow-up that she may have. Representative Drummond.
Thank you, Mr. Chairman. Can you hear me?
Yes.
Great, thank you. Ms. Carpenter, you're the only one who mentioned so far the number of beds available. If you could repeat them. I think you said Fairbanks, Anchorage, and Juneau are the only facilities that are qualify for this definition of subacute mental health facilities.
Through the chair, Representative Drummond, I'll clarify a little bit. So it's who meets our current criteria per statute to be a designated evaluation and treatment facility. So we're not talking about the new facilities that we're trying to expand with this legislation, but those current facilities outside of the Alaska Psychiatric Institute that the department has recognized to do treatment is Fairbanks Memorial Hospital with 20 beds, Matsu Regional Medical Center with 16 beds, and Bartlett Regional Medical Center with 12 beds.
Okay, and follow-up, Mr. Chair?
Representative Drummond.
Okay, and that was outside of API, which is how many beds? 80?
Through the chair, Representative Drummond, when API is at full capacity, that is 80 beds, but I will note that 10 of those beds are for forensic care. So those who are on a criminal charge that the court has found incompetent to stand trial.
Okay. Mr. Chairman, my follow-up would be, are these facilities currently maxed out, and do they have space to take on additional individuals who are defined to be in crisis and needing such care?
Through the chair, Representative Drummond, I would say you're absolutely correct. These facilities are maxed out, and you can, see that by the wait list that individuals have to get into care. That can vary depending on the day. We have, we have an individual in the commissioner's office that gets those reports every day of who is being held and what the wait lists are at the various facilities. But, depending on where anybody is at in receiving care, they may not be able to take more individuals. And the whole point is, we want to get individuals into care to address their psychiatric crisis more quickly, so that way if they can be stabilized at that lower level of care, they're going to never need those beds that I mentioned, that are the highest need, that need, up to a 30-day inpatient stay.
Follow up, Mr. Chair.
Representative Drummond.
And currently these, let's see, 38 beds, 48 beds outside of API. Are those the beds where individuals under this bill will be evaluated and stabilized and treated?
Through the chair, Representative Drummond, those are the beds that currently exist. So we're not taking that away, and individuals we still imagine will flow into the system through those resources and be evaluated in those communities. However, this bill is expanding to allow crisis residential centers, because they'll have somebody up to 7 days, so that allows for that full 72-hour evaluation, that they can have somebody in, do that stabilization. Hopefully, they'll be able to, whether they need a quick medication or quick treatment, whatever it is, and then be, released back to their life. So we see this as adding to the current system, and quite frankly, something that our system has been moving towards with the 1115 behavioral health waiver, with the efforts with the trust, and something our providers have just really desperately asked for, because we need to do better for the current system, and the current system cannot meet the needs that we currently have.
Okay, Mr. Chairman, one more follow-up.
Representative Drummond.
And are there sufficient beds in these residential centers that aren't the full-scale hospital beds that you described outside of API? Are there sufficient beds currently? Is this bill going to allow more of those to be developed, or are we in a good place in terms of what we currently have in the state?
Through the chair, Representative Drummond, I'd be happy to follow up with the committee to share what facilities have already, alluded to the department, or basically asked for permission for the department to stand up under 1115 waiver. That'll give you a good reference on kind of where these facilities are on a voluntary basis, throughout the state. And I'd be remiss if I didn't say, our goal with that is to get these facilities and these resources in all 9 regions that the 1115 waiver, represents. Additionally, I'm being told that 15 agencies to date have been approved to do this service. And, this bill, just like we have now, where it was only those 3 hospitals that I mentioned, have, stood up to do this where they can accept an involuntary patient. Not all of those facilities who have signed up with the department will be ready, even this year, to take on that extra level that is needed with an involuntary commitment. But this starts that process. So without this, none of those facilities could take an involuntary commitment. And we know some are very interested. We know of a place in Anchorage that is very interested in looking at standing up both crisis stabilization and crisis residential under this, model to receive involuntary patients. So we definitely see this as expanding the number of beds, just as our system continues to grow under the 1115.
Okay, great. Thank you very much.
Just as a kind of a follow-up, and I think Ms. Carpenter can correct me, but the essence of this bill is to create the licensing structure so we can have crisis residential centers, because right now, somebody may be able to do something voluntarily, but effectively there are no crisis residential centers in Alaska. We passed a bill a couple of years ago that allows crisis stabilization centers, but that's only the 23-hour facility. And I think the provider's response has been that without the residential centers, it's hard to just get the stabilization center alone. So So at some level, there are none of them today because this bill creates the licensing so they can create them, and then you have providers in line. I saw that Mr. Regan had his hand up, or had his electronic hand raised. I think he wanted to add something. Go ahead and make the comments. I'm not sure whether it's response to this question or something else, but go ahead. Oh, we don't hear you yet. If we can get Mr. Regan unmuted, or maybe he needs to unmute himself. There you go.
I hope I'm unmuted.
Now we can hear you.
Mr. Chair, Mark Regan, Disability Law Center. This is actually in response to one of Representative Eastman's questions about legal protections for people who are brought into the system through a mistake or worse by a health officer or a peace officer. Let me add to what Ms. Carpenter said, that suppose that a peace officer, to use your example, says because you say you are unvaccinated, you are a danger to yourself or to others. We would hope that the training that the peace officers have gotten through our settlement and other things will make sure they know that in order to be the subject of a mental health hold, it has to be a mental illness that is precipitating the problem. And so we would hope that the training that peace officers and health officers would get would tell them to look for a mental illness, because that's part of the system. And so they wouldn't go about bringing someone into custody on that theory because it's not a mental illness that's precipitating the difference of opinion. The other first line of defense of people's rights is if you are brought in, and this is true of API today, and it would be true of crisis stabilization or crisis residential centers, when they do the emergency evaluation, they too will be looking for signs of mental illness. And if they don't have a sign of mental illness, they will release the person. So first, appropriate training will stop somebody from being taken into custody under the situation. And second, if something goes wrong, the person will be released by the first evaluator. So that's how the system is meant to guard against the situation that you're describing.
Thank you.
Next in the queue, I have Representative Vance.
Thank you, Mr. Chair. I apologize for, has there already been discussion on the fiscal notes and a thorough explanation of them? Because we have several, and I'd like to understand how the Mental Health Trust funding and the GF funding is working together, because I'm seeing on the fiscal note from Department of Family and Community Services starts out small for this year, and then it dramatically climbs for the next 5 years. And I would just like to have more understanding of that.
It's fine. Let's say I think either going to be Ms. Carpenter or Mr. Williams. I would note that one of the fiscal notes, which was the court system fiscal note, Ms. Mead was here. She talked about the two positions.
That's fine.
She's gone. She didn't talk in more detail. But as to the other fiscal notes, Ms. Carpenter, do you want to start with those, or is that a Mr. Williams approach?
Chairman Clayman, I think Steve Williams is going to be happy to let us handle the fiscal notes, and he can talk about the trust investment in the overall system. I will say, I'll give a couple of context overview, and then I'm going to have Director Moreau Johnson kind of answer the details. So in terms of the fiscal note for Department of Family and Community Services, the reason you see the fiscal note grow is we're estimating how many facilities, are going to start and kind of raise their hand at the beginning to accept these involuntary patients. There's also a provision in current state statute that requires when there is no other funding source for the state to cover that that care for somebody who is involuntarily committed. So how we do that now is we actually leverage what we call disproportionate share hospital funds that the federal government makes available through the Medicaid program. But those are only available to hospitals. And they are not available to tribally operated hospitals. So we, in this fiscal note, have a blend of when you see the number of DISH qualifying facilities, that's where we can leverage that CMS Medicaid DISH funding, the Fed and the UGF match. And then we have facilities that we imagine would not be DISH qualifying facilities. Say, for instance, a tribally run hospital sets up a crisis residential center, or a standalone crisis residential center that is not connected to a hospital at all. So with that, I can, if there's a more specific question, I can kick that to Director Jennifer Moreau-Johnson.
Representative Vance, do you want more detail?
Thank you for that. I think I'm going to have to step back and take a look at all of them, of the overall ask and how much obligation we're going to have in the general fund for the future is kind of what I'm getting at, but I may have to do that on my own. But thank you for that.
Okay. Any other questions in connection with the fiscal note? Did anybody other than what we heard from Ms. Carpenter, anybody online want to provide any further detail on the fiscal note, or was everybody happy with what she's provided? I guess, Mr. Williams, do you want to provide some insight in terms of the trust perspective moving forward?
Thank you, Mr. Chair. To Representative Vance and the rest of the committee, this is a partnership and initiative that's being carried both by the Department of Health and Social Services and the Trust. And just to give the committee a sense of the order of magnitude that the Trust is investing with the department using trust funds into implementing this effort, in FY 23, our Board of Trustees has approved $4.5 million of trust funds to work with the communities and the department to develop and implement the pieces of the model. And in FY22 and in FY21, there was roughly the same order of trust investment in this process. And as many of you know that have been in the legislature for several years, this is where the trust really steps up and tries to evolve and improve and enhance the system over time, is to be able to use our funding to be catalytic to effectuate a positive change that is dramatically needed for our behavioral health crisis system of care, as is indicated by the lawsuit that was filed by the state against the state a couple of years ago. So we are working hand in hand with the department, our community providers who are going to be critical to standing up these services, and are looking forward to our continued work in this regard.
Representative Vance, sorry.
Thank you. I do have a question about, is there, and Ms. Carpenter may have touched on this, and I didn't quite hear it, but are we having more partnership with the tribes in utilizing the federal dollars that they have through their tribal health to be able to partner in this and have more stakeholders to be able to take advantage of the funding that's available, but also making sure that the communication, the collaboration is with those regional hospitals, as you said, and being able to provide for that rural need.
Through the chair, Representative Vance, the department communicates with our strong tribal partners, weekly on lots of different issues, and the Division of Behavioral Health does so in addition to what we're doing in the Commissioner's office. And I will just highlight that we have certain tribal providers, such as Manilik and Norton Sound and YK, that have already signed up with the Division of Behavioral Health to do some of these services. Additionally, when a tribal provider stands up these services through the 1115 waiver and is serving a tribal beneficiary, the state is able to pull down 100% Medicaid funding or that federal, FMAP match for that individual receiving care. So then the general fund is actually not paying for any of that care. It's the federal government that is paying, our tribal partners 100% to do these services. So we are leveraging those opportunities continuously with our tribal partners. And as I mentioned before, those behavioral health regions, we can't provide these services in each region without our tribal partners. In many regions, they're the only providers out there. And if we're able to stand up these crisis stabilization services, say in Kotzebue and Nome and Bethel, then we're able to get these individuals to have care right there at home instead of having to get on a plane and fly into Anchorage or Fairbanks and, spend more money on travel.
Thank you. That was helpful.
Representative Eastman.
Thank you, through the chair. Now, the DETs we're talking about, are those all subject to local ordinance as far as, internal policies like masking or those sort of things, or are they subject to state or federal policies that would sort of, take precedence over the local communities'
Representative
policies?
Eastman, what does that question have to do with crisis residential?
Yeah, I'm trying to understand who has the authority to set all the policies for those crisis
Well, I mean,
residential
I
centers.
understand that, and I know this whole masking topic is a live issue for some folks, but I guess I'm a little lost as what relevance that has in any way with what we're discussing for this bill.
I'm wanting to understand the legal authority for who's running these facilities.
I don't have any problem with them answering questions about who's running the facilities and the legal authority, but we're not going down, this is not a hearing about mask mandates, so we're not going into masks. This is who runs the facilities and who licenses the facilities. Ms. Carpenter, can you answer as to the DETs that are here today, who runs those and who licenses those?
Sure. Through the chair, Representative Eastman, each of the hospitals that operates a DET has a little bit of a different ownership structure. And I will note that, they have to follow, because they're a hospital that bills Medicaid and Medicare, they have all of the CMS rules and oversight that they have to follow, that the department actually has healthcare facility licensing that goes in and makes sure, that they're following all the rules to be accredited. In terms of the ownership structure, Fairbanks Memorial Hospital is actually a community-owned hospital. They're owned by their foundation. So they set the rules for their hospital that, fall outside of anything that is required by their accrediting bodies. Matsu Regional Medical Center is joint owned by the Matsu Health Foundation. And their co-operator. And if I'm getting this wrong, the hospitals will correct me later. And then Bartlett Regional Medical Hospital is actually owned here in Juneau by the borough. So that is their ownership structure. But again, there's lots of accrediting bodies such as CMS, the Joint Commission, that oversee, the rules they have to follow.
Thank you.
All right. I don't see anyone else with their hands raised. I don't hear anybody online that could be asking more questions. I don't have any more questions. And so we are going to hold this bill for further review. We will now adjourn for the day. Our next meeting is Wednesday, February 23rd at 1:30 p.m. As I announced last week, if anyone is considering offering an amendment to House Bill 172, please let our office know and submit them electronically by 5 p.m. on Tuesday, February 22nd, which is tomorrow. It is my intention to take amendments to House Bill 172 during our meeting on Wednesday, February 23rd, and then pass the bill in a committee following final questions and discussions. And with that, we will stand adjourned. The time is now approximately 2:42 p.m.